I'm Blake Mahoney, and this is the interpretation and understanding of 303 Creative LLC versus Elenis by local business owners. In the United States of America, there are certain rights that all citizens are promised. These rights include the right to pursue happiness, start a family, speak our mind, participate in the free market, and more. While these all may seem like basic concepts that we often take for granted, for some, these rights are not guaranteed. For decades now, a war between religious rights groups and LGBT rights groups has been waged throughout the American legal system. LGBT groups want the right to fully participate in the free market, while religious rights advocates want the right to refuse service when they feel their beliefs are being contradicted. The most recent example of this battle is the 2023 Supreme Court case 303 Creative LLC versus Elenis. In this case, the owner of a Colorado-based graphic design business, Lori Smith, wished to expand her services to include the creation of wedding websites. However, Smith wished to post a statement on her website stating that she would not create websites for same-sex couples. She believed that by creating a website for a same-sex wedding, she would be expressing views contradictory to her religious beliefs. Smith feared, however, that the Colorado Anti-Discrimination Law, or CADA, would not allow her to do so. CADA is a law in Colorado that outlaws discrimination in public places based on race, religion, and sexual orientation. Her response to this fear was to sue the state of Colorado, claiming that CADA violated her First Amendment rights. The case made its way through the court system all the way up to the Supreme Court. When it reached the Supreme Court, they ruled 6-3 in favor of Lori Smith and 303 Creative LLC. In their ruling, they stated that by forcing Smith to express views that were contradictory to her own, CADA violated her First Amendment rights. The 6 judges who ruled in the majority stated that Smith's refusal to serve same-sex couples was not discrimination, but just a preservation of her constitutional rights. So what does this ruling actually do? It doesn't, as some may believe, strike down discrimination laws. The Colorado Anti-Discrimination Act challenged in the case is actually still standing. In fact, the majority opinion specifically stated that anti-discrimination in public accommodation laws are not inherently unconstitutional, but that forcing businesses to create art that contradicts their values is. The court classified a wedding website as a form of art because they believed that it would be Smith's own views expressed through the creation of the website. However, the court declined to define what qualifies as expressive activity protected by the First Amendment. This leaves the question of which services and goods exactly are allowed to be denied to people due to their sexual orientation. Due to the fact that this case is so recent and that the ruling itself is fairly vague, how exactly this decision will affect same-sex couples, business owners, and other groups in the marketplace is still unknown. In my research, I hope to answer the question of how local business owners understand and interpret the 303 decision, and if it's affecting the way that they operate their businesses. Will this ruling be used as a way for business owners to act on prejudices and exclude people from their business, or will it truly only be used to protect the religious freedom of expressive business owners? There is such a scarce amount of research into this case because of how new it is. Pretty much all of the existing research is exclusively looking into the background and the facts of the case, not its application. Understanding the effects that this case will have on local economies and business practices is extremely important, even for people who don't identify as LGBT. If the case is being improperly used as a blank check to discriminate against people whose lifestyle a business owner doesn't agree with, then legislation needs to be passed to ensure that consumer rights are being protected. Martin Luther King famously stated that injustice anywhere is a threat to justice everywhere. If we turn a blind eye to discrimination in our local communities, we are allowing injustice to take root. By shining a light on the ways that this case will be used, I hope to ward off that potential discrimination and injustice. When analyzing the effects of the 303 Creative case, one must ask to what extent expressive businesses are allowed to refuse service and to whom they are allowed to refuse service to. A 2023 essay by Carlos A. Ball, a professor at Rutgers Law School, looked into how the court's reasoning and decision in the case would affect whom businesses could actually refuse service to and why. Ball points out how the court distinguished objecting to serving same-sex couples from objecting to serving members of protected racial groups. The attorney arguing Smith's side of the case pointed out how in the case of Obergefell v. Hodges, 2016, the court described people who oppose same-sex marriage as reasonable and sincere people, and that their biases are based on honorable, religious, and philosophical premises. The court distinguished this from individuals who discriminate against racial groups because their motivation in doing so is not justifiable. When Justice Samuel Alito asked the attorney whether it would be honorable to discriminate based on race, she said that it would not. This article found that the court's ruling in this case did not affect earlier precedents that rejected First Amendment protections granted to business owners who were bigoted against certain racial groups, and therefore contain the effects of the case to not apply or to not apply to any racial civil rights groups. Even though the outcome of this case does still leave civil rights protections in place for racial groups, it does appear to open the door to some level of discrimination. A 2023 research paper by Mark Sada, a professor at Wayne State University, argues that Lorie Smith essentially used selective commercial service to discriminate under the guise of religious expression. The paper makes a point of setting this case apart from other recent cases concerning religious expression and LGBT rights, as she not only wished to not have to serve same-sex customers, but also wanted to be able to preemptively display a message saying that she would not serve them. The author argues that Smith is not simply abstaining from serving customers that she does not agree with, but proactively using market discrimination to exclude those people from her corner of the marketplace. By making the decision that they did, the court seemed to set the precedent that the expressive freedom of a service provider trumps the rights of consumers to fully participate in the marketplace. 303 Creative LLC versus Alanis is not the first case of its kind to appear before the Supreme Court. Back in 2016, the court heard the case of Masterpiece Cake Shop versus Colorado Civil Rights Commission. This case is very similar to 303 in that they both deal with a Colorado business owner who wished to refuse service to a same-sex couple. In Masterpiece, the court ruled in the favor of the business owner, but did so on the grounds that the Colorado Civil Rights Commission showed unfair prejudice toward him. This case and its effects are discussed in a 2018 article by Sarah Posner, a journalist who specializes in religious rights issues. Posner argues that because the ruling was based on the treatment of the business owners by the commission, it didn't actually provide exemption from anti-discrimination laws. The ruling only applied to this specific case because it concerned specific comments made by the Colorado Civil Rights Commission that the court deemed hostile. Posner notes that without these particular facts, a different case could lead to a different result. 303 Creative is that different case. Due to the fact that it deals with the actual legality of refusing service to certain customers and not with the actions of the Colorado Civil Rights Commission, 303 has actual concrete effects, not only for this specific case, but for all Americans. The primary method I use to collect my data is semi-structured interviews. This method is ideal for my research because I do want hard answers to certain questions, but I would also be able to use unscripted questions to probe deeper into the business owner's understandings and opinions of the 303 Creative case. This method allowed me to get the clearest and most complete picture of how the case is being interpreted and applied by local business owners. If I were to go with a structured interview format, I would be able to get answers to the main questions I wanted to ask, but I wouldn't be able to know the reasoning behind these specific answers or go deeper into their opinions and viewpoints. I also could have done survey, but that would have made it easier for the subjects to give inaccurate answers and more likely that they wouldn't provide an adequate amount of information, as well as just like the structured interviews, not allowing me to probe deeper into their answers or reasoning. The first step of my research process was recruiting subjects. I did this by reaching out to business owners through email, explaining my study and what their level of involvement would be. I obtained 3 business owners as subjects, not concentrated in a single industry or business type. I studied both businesses commonly identified as expressive and those that are not commonly seen as such. Once I selected my subjects, I arranged interviews with each of the business owners separately. In these interviews, I started by answering my pre-structured questions. These questions gave me an idea of how familiar with the case the subject is and whether or not they plan to change their business practice due to the ruling. I started by asking them if they had heard of the case, and if they had, I asked them if they could describe it to me. If they were unfamiliar with the case, I described it to them and saw if they were familiar with either the case or the general concept based on the description. I then asked them how they interpret the ruling of the case, what rights they believe it grants them, and if they have exercised or would exercise these perceived rights. Since the case specifies that the ruling only applies to expressive businesses, I asked them if they consider their business an expressive business. Finally, I asked the subject whether or not they believe religious beliefs should play a role in business ownership, and whether or not it plays a role in how they run their own business. Throughout the process, I also asked follow-up questions to push deeper into their answers to these plain questions. In order to analyze the data from my interviews, I used a content analysis method. All of the subjects' answers to the questions were recorded on paper, and I combed back through their answers and used inductive coding in order to analyze them. I looked for patterns in understanding, interpretation, and application across all the subjects. I used these patterns to determine trends in how the 303 Creative LLC versus Alanis case is affecting local customers, their local businesses, their owners, and their customers. The three business owners I ended up interviewing included a bakery owner, a restaurant owner, and a shoe store owner. After completing the three interviews, each of which took between 15 and 20 minutes, I used inductive coding to begin my analysis. Through the coding process, I was able to identify patterns in the familiarity, interpretation, and application of the case. Business owners from these three different types of businesses shared similar ideas about the case, but with a few differences. This allowed me to create a general image of how the case impacts the business practices of the subjects. So starting off with familiarity, I started off the interviews by asking the subjects if they were familiar with the Supreme Court case 303 Creative LLC v. Salinas, which occurred in the summer of 2022. Based on just this information, none of the subjects had heard of or were familiar with the case. I then proceeded to explain the facts of the case to them. After this description, all the subjects claimed that the case sounded familiar to them. The bakery owner elaborated, saying that she was aware of cases that dealt with similar issues to 303 Creative and knew that the court generally ruled in favor of religious rights in these cases, which is a correct observation. Now looking at how they interpret it, the next question that the subjects were asked was what rights they believed this case granted to them. The bakery owner said that she believed it gave her the right to refuse clients who request her to produce a product that goes against what she believes in. The restaurant owner stated that the case gives her the right to be discriminatory and refuse service based on race, sexual orientation, religion, or other categories. The shoe store owner believes that the ruling makes it so that he doesn't have to sell to anyone that he doesn't want to and allow him to do what he wants with his business based on what he believes in. Both the bakery owner and the restaurant owner went further, stating that they believed this right to be one that they had already had, and that the case did not expand or contract their rights in any way. The subjects were then asked whether or not they considered their business to be an expressive business. The bakery owner said that she did because her business allowed her to be creative in some ways, and she does see her cakes as creative products. She believes her cakes are a form of expression, and having her name stamped on inappropriate cakes would hurt her reputation. Neither the restaurant owner or the shoe store owner identified their businesses as expressive. Now looking at the application. The subjects were then asked if they would exercise the rights granted or outlined in this ruling, and if they have exercised these rights previously. The bakery owner said that she had turned away customers before on the ground that the messages or images that they requested to be printed on cakes were phallic, pornographic, or otherwise inappropriate. The restaurant owner didn't firmly say whether or not she would exercise it, but she did say that she believed she could refuse to hold a wedding reception for a same-sex couple if she didn't agree with them. The shoe store owner said that he couldn't think of any scenarios where he would have to refuse service to anyone, but would be willing to do so if the situation arose. These interviews paint an interesting picture of how the 303 Creative LLC v. Salinas case is known, interpreted, and applied in different businesses within this community. There appears to be general uniformity across the answers in the familiarity and interpretation categories, and some variance in the answers concerning application. All of the subjects seem to favor interpretations and applications that prioritize their rights as business owners over the rights of consumers. Even though they weren't immediately familiar with the case, they believed that the rights the case affirmed were rights that they already had as business owners. Based on the uniformity of some of the answers, despite the differences in types of business, assumptions about other business owners within the same community can be drawn from the data. The first assumption that can be drawn is that most business owners within the community are probably not familiar with the case itself. However, there's most likely a portion of them that are aware of similar cases and are aware of the case itself, and are aware that the Supreme Courts tend to rule in their favor. This assumption can be drawn based on the fact that most of them weren't familiar with the case, but the bakery owner was familiar with the concept in similar cases and knew about the general legal history of this issue. Another assumption that can be drawn from the data is that local business owners interpret the ruling in this case as affirming, not granting, the right to refuse service to pretty much anyone they want. All the subjects that I interviewed believed that this was a right that they already had, and that this ruling did not grant or take away any right to or from them, but instead affirmed rights that they already had. They all believed that this case affirmed their right to refuse service, but each posed differing levels of restrictions to their wordings. One issue that could arise from having just surface level understanding of the case and its related cases, as most of the subjects do, is the misapplication of their rulings. For instance, the related case that most business owners are probably familiar with is the Masterpiece Cake Shop decision, as this case received a lot of press coverage while it was occurring. The general understanding of this case is that it sided with the business owner who refused service to a same-sex couple. However, most people don't know that the reason the Supreme Court sided with the business owner was due to the way that the case was handled by the courts in Colorado, and that the ruling didn't necessarily grant any rights to the business owners when it came to refusing service. This common misunderstanding of the case that comes from having only a surface level familiarity with the issue, such as that displayed by the subjects in the study, may lead business owners to believe that they have rights that they actually don't and to discriminate against people that they don't have the right to. There was a number of clear misinterpretations present within these interviews. The first and most clear one is the restaurant owner and shoe store owner who believed that this case granted them the right to discriminate, while also stating that they didn't view their businesses as expressive, which is a clear misinterpretation of this ruling, as it specified that it only gave the right to refuse service to expressive businesses. The final set of answers helped to paint a picture of how the subject's right to refuse service, or their perception of this right, was actually being applied in real life. Both the restaurant owner and the shoe store owner said that they had never had a situation where they felt the need to exercise the right to refuse service, while the bakery owner shared that she had refused to produce cakes with certain messages on a variety of occasions. In short, all of the business owners were unfamiliar with the case based on just the name, but were familiar with the general idea of the case once I described it. There was broad misinterpretation of the case from all of the subjects and differing approaches to how the subjects believed the ruling should be applied. All of the subjects seemed to believe that they had more right to refuse service as business owners than they actually do according to the law. This misunderstanding of rights among business owners could lead to consumers being unjustly discriminated against. To remedy this, the government should do a better job of educating business owners on when and why they are actually allowed to refuse service to customers and how specific court rulings apply to them. The law is a very complicated, fluid thing, and not understanding certain parts of it can lead to unintentional wrongdoing towards others. Thank you very much. I'm excited. Thank you.